Hey, y'all. Welcome. Episode 77 of Gabfocus. I'm Tommy with StoragePug. Melissa, how's your world? How's your day going?
It's fall, y'all, and I get to decorate for Christmas in like a week. So I am so excited.
It
So,
is fall. It was nice. It was 39 degrees in Chile this morning in Knoxville.
hmm
I loved it. My
yep.
daughter had a coat on going to school. So always fun. But y'all, this is a big episode. So I want to jump right into it. Honestly, it's our annual legal episode this year. We love to rotate between all the legal experts, but I always love it when my man Joe comes. Joe, welcome back to the Gap Focus stage. He's the chief legal counsel over at the National SSA. How are you, my friend? How are you doing over there?
I'm doing great, Tommy. Good to be with you and Melissa again. And I always love looking at that photo because it's like I did look like that once upon a time.
I
It's
feel the
maybe
same.
maybe the first time I was on the show.
I feel the same with my default photos. Like, that was before kids. It's
Yeah,
different.
yeah.
Yeah.
Oh my gosh. No, you look handsome as ever. And honestly, I'm always glad to have you on because y'all do such a good job. And in during lobby talk, Melissa mentioned it. There's a legal resources that if you're not already part of the association, that's worth the price of admission times 10. But then, of course, y'all keep track of national news, state level stuff, and so this is a great episode. And we always do a call for questions. For context, y'all, we always do a call for questions before the show. We'll send an email out. We had so many responses for this one. We had 13 already lined up, and there's already a handful in the Q&A loaded, ready to go for this one. So, y'all, welcome. Gap Focus, of course, brought to you by my team here at StoragePug in Knoxville and Melissa's team at Lighthouse Storage Solutions down in Chattanooga. And if you're new here, welcome. You chose a really good one because this is our annual legal update. We'll go for about an hour. Melissa and I will take turns asking all the questions. Joe will be our resident expert to answer those questions. And again, we have pre-submitted questions from the audience, and you all can go ahead and submit your questions in the live Q&A tool while we go through the show. So without further ado, Melissa, you want to get us started?
Yeah.
Let's
Yeah.
do it.
Let's
Jumping
just
right in.
dive right in, Joe. What is the legal climate currently like for our industry?
Broadly speaking, it's very positive. What I like to say is that self-storage is the envy of the commercial real estate world because we don't have this messy process of going into court and evicting people. We are largely governed by our rental agreements and generally pretty friendly lien laws. Even in the states where they might be relatively more difficult than other states, the process is still pretty amazing. And yeah, compared to self-storage is kind of that also that real estate retail hybrid. Compared to retail, we're also in an advantageous position legally. We don't have the same types of risks that they do, largely because our relationships are governed by contract. It's not, yeah, so that cuts off a lot of the class action and other type of stuff that the retail industry could see. So broadly speaking, very positive, but as we'll get into, there are some concerns out there that yeah, that we all need to be aware of, both legislatively and in the courts.
I love to hear that it's positive, and you're
Yeah.
right about yeah, us versus, but like, yeah, self storage compared to office buildings or even residential real estate. It is, yeah, we have a different set of rules that are fortunate because we're not having to deal with like real people in storing themselves. We're dealing with their stuff.
Hopefully not.
Hopefully not. Uh hey, by the
That's
way,
We
I
the
can
just
talk about
unlegal
that, but
question.
that should not be happening.
that should not be happening. Hey, by the way, I just saw Scott Zucker pop in. So Scott, welcome to the party. I would love to, if you would love to, you're welcome to chime in on any of these questions in the comments. So we have two legal experts, at least two that I can see here. So glad to have you here. Well, so talk us through this. So overall, very positive. I'm in love with that. Talk to us trends, right? Across all the different states. Are there common occurrences or common trends that you're seeing that are impacting states from California all the way to the East Coast?
Yeah, so in terms of positive trends, I'll talk about what Melissa and I and the Tennessee Association and some other states have worked on over the last couple of years. So we're all familiar with the legal lien process that exists in every state but Alaska. Yeah, don't get me going on Alaska, but every state but Alaska has a lien law. The gap we identified over the last couple of years was, well, what happens if somebody's paying, but you get rid of them for another reason? You know, for example, as we've already talked about, they're living in the unit, they're doing something illegal, they're harassing a manager, they've damaged your property, whatever the case may be. What's the process for dealing with those people? And then second, you acquire a new facility, whether you're managing, owning, whatever the case may be, and you want to get those people, customers at that facility on your rental agreement. Yeah, how can you be confident that you can bind them to that agreement if they don't sign it? And inevitably, there are some people who, for whatever reason, just won't sign that new agreement. So in terms of positive trends, those are issues that have now been addressed in statute in about a dozen states.
Wow.
And it probably be addressed in maybe 6, 7, 8 states again next year, so we can get that number up even higher and ensure that owners aren't kind of in that where I hate for us to be as an industry. And I think we can talk about this today, is that kind of like, well, should I do it this way or should I do it that way? Because the law doesn't guide me exactly how I should do it. So what we're looking for is both uniformity across the states and clarity on a process that can be um, vary from contract to contract. We want a single standard of, okay, this is how we do it, and if we do it this way, we know we did it right.
Mm-hmm. Yep. We like those industry standard conversations. Makes everything a lot easier when you can approach it that way. Is there anything in particular that owners should be concerned about?
Yeah, so in terms of negative trends, the biggest ones that I'm concerned about are actually coming from outside of the self-storage industry. We can talk about the rent control issue a little bit later. I wouldn't call that right now a trend. It's certainly something that's popped up, but it's
Mhm.
not yet, and I hope never a trend. But in terms of trends, my biggest concern is around junk fee laws.
Mm,
And that's something that came up, frankly, because of some bad actors in other industries,
Mhm.
mainly around live event ticketing and hotels. We've all dealt with that situation where you're buying a ticket to whatever game, the Tennessee game, or the Chicago Cubs baseball game, or you're going to a Taylor Swift concert, and it's X dollars when you first sign in, and then it's X plus $200 when you're at the checkout. And you're like, what the heck happened?
Mhm.
yeah.
And or you're dealing with a resort fee at a hotel that gets sprung on you at the last minute. So because of that activity in other industries, we've seen this trend of junk fee laws that started, not surprisingly, in California, and then went to Minnesota, and now it's gone to Colorado and a handful of other states. And it's one of these that, unlike some other issues, it's not solely a Republican or Democrat issue. We have a Republican governor here in Virginia, Democrat-led legislature, but a Republican governor who could have vetoed the junk fee bill if the legislature passed and he signed it. So it's not
Mm,
strictly a partisan issue,
yeah.
but
Mhm.
that's something we're gonna see more of that over the next few years for sure.
I'm a fan, to be honest. I mean, dare I say, Ticketmaster is one of the most loathed companies on our planet.
Yeah.
And Airbnb, really hurt themselves when you book $180 a night room, and then by the end of it, you paid an extra $100 in four different fees.
Yeah.
No one
Yeah.
likes that, right? So I think consumer friendly. I think there's obviously there's a line to be crossed, and hopefully, the legislation and the regulations don't make it too hard to conduct business online. But I think overall, hopefully, it's a positive trend, and I've seen it from our own clients, who especially, and actually we worked with Joe and Scott Zucker, who's in the room, and to figure out, okay, how does this impact self-storage operators? And we implemented some cool changes that I thought were really good reflections. And I've got actually feedback from our clients that say, hey, the fact that we're leading with transparent pricing and honest pricing, that's now a marketing tool.
Yeah. Yeah.
And we can actually say that we are transparent, we are honest, there are no hidden fees, and we can lead with that now. So that was actually potentially a positive change. And I think the concern that we had, especially with the California legislation, I don't remember the Minnesota one as much, but it wasn't clear what we were supposed to do. Like, it's like, you're not supposed to do this thing that's kind of gray and blurry, but it doesn't have true guidance on like how to properly do it the right way, if that makes sense. So I want to give kudos to SSA and Joe to kind of help us figure out what we felt was fair.
Yeah, and it is something that's tricky because the examples that we're talking about are one-off situations. It's not like an ongoing relationship. So you buy a ticket, you stay at a hotel. It's a one-off thing. Self-storage as a recurring month-to-month transaction, it gets a little tricky. And what we've seen in Minnesota and then more recently in Massachusetts and Colorado is that the first month payment to move in needs to be expressed as a single number. California doesn't have that requirement. A few other states with these laws don't have that requirement. And it makes it tricky around, well, how do I properly communicate the admin fee to the customer and that's only a one-time fee?
Right.
So it's going to be complicated for owners to figure out exactly how they want to comply with that. But overall, I think the trend to regulate junk fees is probably something we're certainly going to see more of it. And it's something that is what I like to say is, if you're the consumer, and you pointed out this, Tommy, if you're the consumer, you hate these fees. So what do you expect your consumers to see? And it's something I think as you see more of these laws passed, there's going to become an expectation, even in the states that don't have the laws yet, that's how pricing is communicated and made transparent to the consumer.
Do you think we may see the end of admin fees just because of the confusion that it can cause, especially if I'm the operator and I'm having to list all of these things, but then my competitor says, "Oh, I don't have that." That might be a negative. So I just wonder if this might actually spell the end for admin fees altogether.
It would not surprise me, Melissa, because I think especially in the states where the price has to be given as a single number, it just gets complicated then to have to I have to put that higher number, and then I have to put an asterisk to explain that part of that number is only a one-time fee. Maybe
Right.
maybe the juice isn't worth the squeeze anymore.
Wow.
Yeah.
Yeah.
Hmm.
That's
Okay.
tough. Yeah.
Something
So
to consider for
things
sure.
to unravel, over the next couple years. So you kind of mentioned the rent control. So speak broadly about that. We'll dive in more specifically, throughout the rest of session here. But like, what are the different rent control things that have propped up? I know, California is one of the places it started. New York was another place. Georgia had a big one. What's the latest movement on those activities?
So they initially came up in all places, Hoboken, New Jersey, a little city outside of New York. I want to say 2019, 2020, and it was just kind of like a one-off thing, and it went away as quickly as it came up. We never even got an explanation of where it came from, and then we thought, oh, well, that's kind of weird, but whatever, and just kind of moved on. And then popped up again a few years later in Texas, and then, as you pointed out, Tommy, Georgia, New York City, and then most recently in California. The the through line with all of those pieces of legislation is that it was either a negative experience that the legislator, him or herself, had, or a negative experience that somebody close to that legislator had. Uh, it has not so far been something, and I know this is something we'll probably get into with the activity around ECRIs. That has not been the driver of these pieces of legislation. But we can get at how those ECRIs have factored in, but they have not been the cause for why the legislation has been introduced, at least broadly speaking. It's just been, well, I had a negative experience as a consumer. I'm a legislator. Legislators file bills. I'm going to assume that other people had this experience. Maybe they did, maybe they didn't, but I'm going to file this bill and just see where it goes.
Okay, interesting. I would have thought that the ECRIs had more to do with it. So
Yeah, for real. Yeah.
I guess that's good for us because we do need to continue to still be able to do those. Um, Website privacy suits in California. What is up with that?
Yeah, so there's yeah, there are a few different statutes that plaintiffs' lawyers are exploiting in California and other states as well. Actually, Florida and Pennsylvania have seen some of
Mm.
these as well. I would say, generally speaking, there have been some favorable decisions from the courts that have tamped down on expectations of plaintiffs' lawyers, but not uniformly. So these cases, I was just reading a decision that came out within the last couple days that was favorable to the defendants, the companies being sued. But then there have been plenty of other decisions that have concluded the opposite way. So there's still a little bit of fuel out there for the plaintiffs' lawyers on these. Um,
Mhm.
but broadly speaking, they are exploiting wiretap laws that were not intended to deal with the internet. They're passed in the 1960s or 1970s, yeah, kind of Watergate era type of stuff, and they're, again, before the internet was, before Al Gore even invented the internet, these were being were passed. So it's kind of that square peg and round hole type of thing.
Mhm.
But there's enough out there that these plaintiffs' lawyers can say, "Oh, you're wiretapping, or you're perhaps through your pixels, you're sharing information from your website with social media, Facebook, X, whatever the case may be." So there's enough there that, yeah, these cases are at least, uh, yeah, you can at least file them with a straight face. Uh, but the biggest defense that owners can work on is making sure that if they are going to have these type of tracking on their website or share information with social media, that they have information or consent within their terms of use, and that the consumers or the website visitors coming to their site consent to the terms of use. So you want something like a pop-up that comes, they can click on the terms of use. They're never going to do that. They're never going to read them. But if you get something where at any time someone comes to the website, they consent to those terms of use, and we've all seen those type of websites, that's the safest way to to avoid those type of lawsuits, or make them go away very quickly if you have that type of consent on your website.
And there are lots of great tools out there that are free or relatively inexpensive that people can install on their website. If the website doesn't already have that feature built in, just pop, and like Joe said, most of us have seen it, right? This pops a little pop up. Hey, do you accept these cookies or these terms?
Yeah.
Just a yes or no button, or you can just even close it out if you don't want to answer. Um,
Mhm.
so that's good to know. And then on the, the predatory ADA lawsuits, it's always been a thing in our industry. It seemed like there was a little bit more press around it in 2025. Is that something anyone should be worried about at this point in time? And ADA specifically, or these frivolous lawsuits that say your website is not, ADA compliant because it doesn't do X, Y, and Z. And self-storage is one of the industries that are targeted in these kinds of lawsuits? Anything to be worried about right now?
I think my answer might be surprising, and maybe Scott would disagree with my answer. But broadly speaking, I think the risk of a ADA lawsuit against most storage operators is quite remote.
Got it.
80% of the cases are filed in 3 states: California, Florida, and New York. Another 10% are filed in 7 more states, and then the remaining 40 states account for the last 10%. So if you're in a state like Oklahoma, Idaho,
Okay.
Oregon, you're unlikely to ever see any of these type of lawsuits. It doesn't mean you shouldn't comply. There are good reasons to comply with the ADA beyond just, well,
Of
that's what the
course.
law says I should do, and I should, follow the law. There are good reasons to comply with the ADA, but in terms of a threat of litigation, again, the chance is pretty low if you're not in one of those 3 states. And but if you are in California, Florida, or New York, especially California, around ADA facility access type of issues, there are a few firms that file literally thousands of lawsuits, and they'll hit the biggest companies in the industry, but they'll hit some mom and pops too. So that's a state where you've really got to watch yourself. And then on the website cases, particularly, they've slowed down over the last few years. There still are some that come up against storage operators. Those are mostly concentrated in New York and Florida. So if you're operating in those states, even if you're not based there, but if you have facilities there, I would make sure you're particularly sensitive to your website accessibility in those states.
All right, makes sense. Which legal challenges have owners and operators asked you about the most this year?
Yeah, so we were talking about one in lobby talk. I would say largely the types of questions have stayed pretty consistent over my 8 years at the association. Big one, you'd think everybody who rents self-storage dies.
Either
Because
that or they file bankruptcy.
yeah,
One,
yeah,
one of the two.
those are big ones we get
Mhm.
all the time. And then yeah, other questions like the ones we're trying to address through the legislation is, well, I have this person I want to get rid of, but he's paying me. How do I do that? Or I've purchased a facility that doesn't have any rental agreements, or their rental agreements are all index cards. Those
Yep.
type of questions.
Those are my favorite.
So why do you still get those?
Yeah, yeah,
Uh-huh.
no,
Yeah.
I would say 99% of the questions are some variation of about 15 different scenarios, if not like 10.
Mhm.
There are always the oddballs
Yeah.
out there, but there are, speaking of trends, there are a
Mhm.
lot of trends in the type of questions that come up,
Yeah.
because no
Mhm.
matter where you are, there's a lot of similarity in the tenant base of
Yes.
self-storage.
That's
Well,
so true.
well, we have 13 pre-submitted questions. I'm gonna guess that it's gonna be a good spread
Yeah.
and cover 99% of the cases out there. Uh, so you mentioned index cards and rental agreements, right? It's a good segue into like what are the common, still in 8 years of doing this, what are the most common legal mistakes that you see owners make still today in 2025, and how do you recommend them avoid or change or mitigate or grow up so they can stop making these mistakes?
The biggest one, if I'm to kind of word it broadly, I would say letting problems fester.
Mm,
And whether
Okay.
that's a troublesome type of tenant or something within your documentation system, that we all have a tendency to kind of bury our heads and hope the problem goes away. But
Yep.
particularly when you're talking about a problematic tenant, um, y- not to use too gory of an example, but you gotta cut the head off figuratively, not literally.
mhm, mhm.
And because almost every piece of there are a couple of reasons for this. You've got like that 80-20 rule of, and it's
Mhm.
probably even more extreme in self-storage. It's probably like 95-5. Uh, and in, where you have 5% of your tenant base taking up 95% of your time, and those people are just a waste of your time, and you're probably not gonna change their behavior. So you've got to figure out a way to move along from those tenants. And so many of the lawsuits that I've seen filed over the years and negative pieces of legislation, they come from an aggrieved tenant that the storage operator just kind of let hang out there for far too
Mhm.
long.
Mhm.
And then the final thing I'll say on this is, similar to the index card rental agreements, another common theme in the questions I get is, well, I have this tenant who has some exorbitant amount of money of back rent. How do I deal with them? And I say, well, how long has this person been around? Oh, 3 years, 5 years. Like, come on. Even if they're military or bankruptcy type of situation, and there are obviously a lot of reasons to be sensitive in those two particular areas, you got to deal with those a lot faster than years. So
Yeah. Yeah.
Wow.
I
Yeah.
think you're right. You see a lot of people that just hope the problem goes away if they just ignore it long enough. So, do you, along these same lines, do you find that owners, get unnecessarily wrapped up in things that they're worrying about too much that aren't that big of a deal?
yeah, that's a good question, Melissa, and I did think about that, when you all had sent the outline to me. That was a tricky one for me to answer, because I don't want to downplay any particular legal concern, but if I had to pick one, I would say that, especially among smaller operators, there can be an undue concern around class action risk.
Mhm.
Most of the, if not all of the class actions in the industry have largely been concentrated against the biggest companies in the industry, or maybe down to mid-sized type of operators. But if you're operating a handful of facilities, your class action risk is virtually non-existent. And your focus should really be on, am I following the lien process correctly?
Mhm.
Because that, especially for smaller operators, remains the single biggest legal risk that you can have, if you don't have a proper process and consistent process that you follow for enforcing your liens.
Mhm.
I love that. That's such good advice. Just
Yeah.
focus on following the
I
lean
see a lot
process.
of, sorry,
No.
you're cutting out, Tommy. I see a lot of people that they follow the lien process and then get right to the end and then they yank it out of auction
Mm,
because they're afraid to actually follow through with the rest of the
Mhm.
process and they get hung up on, maybe it's because of the contents that are in the unit or who the person is. It's like we have these lien laws in place for a reason so that you can continue to do business and you can get rid of stuff and move on and continue to do business. But I see a lot of people, they waste their time, they go through the whole process, yank it out. And then they sit on it for 2 or 3 months and then they do it again and go through the whole process, get right to the end, and they yank it back out again. So it's like, come on, like use the law the way the way it's supposed to be used, or else you're actually creating more trouble for yourself because you're not following through. So why would they believe you the next time you say you're going to auction the stuff off? Because you've shown them 4 times now in a row that you're not actually going to sell it. So why should they believe you on try number four? So, but I see a lot of that hesitancy.
yep, that Melissa, that's a perfect example of letting the problem fester. You certainly want to do your due diligence beyond just what the minimum requirements of the law are, but you have to pull the trigger.
Right. Right.
Yeah, you said something at the beginning, at the top of the call, Joe, of like having standards that the industry can follow is a really good thing. Like our industry has that for a lot of the pieces, like you mentioned the lien law specifically, and it really works well when we all follow it, and it starts to kind of unravel a little bit when some of us don't,
Right.
and it creates these little wild offshoots or edge cases that can, to your point, fester into much bigger problems, not
Mhm.
only for the individual operator, but the industry at large.
Right.
You know, and I, you know, to because there are probably people in this room who probably have yanked an auction, and I understand where the heart is. You know, like
Mhm.
you know, I understand people want to be empathetic and help out a fellow human when you can, but you know, there are processes, and many times there are good reasons for some
Yeah.
processes. Yeah.
Yeah.
So,
Yep.
well, Joe, we got some good questions from the audience that are live in the Q&A and pre-submitted. But before we get to that, talk to us about next year. So 2026 and beyond, what changes, big or small, do you expect to see next year?
Yeah, so I'm really excited about next year. As we started this conversation off, I'm bullish on the legal position of the industry and the overall landscape. We're looking to add more states that have passed the reforms I was mentioning earlier. And then, but there are still some of those traditional items out there that we had pursued under when Carlos Caslow and Tim Dietz were leading up government affairs, and that Daniel and I have taken up that mantle at the National Association with our state association partners. The traditional items like eliminating newspaper advertising. It's still shocking to me in 2025 that we're talking about having to advertise in newspapers, but there are a dozen to 15 states that still are clinging to that antiquated requirement. So that's another one where we're hoping to make some more progress next year. And the big white whale on newspaper advertising remains Florida, with Texas nipping at the heels. Unfortunately, or fortunately, depending on your perspective, Texas only meets every other year, so we can't work on that until 2027. But Florida meets every year, so we're gonna give that another run. And if I can make a pitch to the folks on the call, uh, first off, join your state and national association, and you're going to get notices from us, whether state or national, about, hey, you need, please call this legislator, please email, please come to this type of event for a legislator. Those emails are not just sent idly. Legislators want to hear from real people like you. They don't want to hear from, if I'm to insult myself a little bit, an empty suit like me. They hear from people like me all the time. They don't hear from people like you all the time. And if you're there explaining why these laws are important to you, that's going to go a lot farther than some paid lobbyist like me, or the other folks that we use in state capitals to pass these. So please take those requests seriously.
Love that.
Yep. They really want to hear from the people who are voting for them.
Absolutely.
Yeah.
Yep.
Joel says 2026 is the year for Florida.
Heck
Woohoo!
yeah, Joel. That's right. That's what I want to hear. Joel knows how it is.
Now we're
Yeah.
talking, Joel.
Love it.
That's awesome. Scott agrees. I love it. Any negative changes? Anything that like we should be at least mindful of and not scared of, but like be prepared for?
Yeah, I think scared is an appropriate word, actually. So we are, whether we see specific rent control legislation next year, time will tell. But
Mm,
there's a lot of conversations going on around affordability all throughout the country, not just in Democrat states, in Republican-led states as well.
Mm,
Yeah, so there are concerns around uh, the use of algorithms and how those factor into setting prices. There are concerns in wildfire and storm prone places around price gouging during storms. And that's one, back to your point, Tommy, of we want to be empathetic to people who are affected by storms. But in a lot of cases, in California being a significant one, these price gouging laws can turn into price controls, because they extend way beyond the usefulness around the storm, and just kind of can continue in some cases for years. So those are the areas where we are hyper focused on making sure that we are either completely defeating or as significantly as we can mitigating the any negative effects of bad legislation against the industry. And that might be something that is specifically directed at the industry, like rent control, or it could be something that's much broader than us: junk fees, algorithmic pricing, price gouging, etc.
Wow.
Lots to consider.
Yes.
Lots to consider, man.
Yeah.
Well,
So
Melissa,
join your state association so you know what's going on.
there you go. There was at least four of y'all who are not in either.
Mm-hmm.
Many of y'all are only one or the other, so step
Mm-hmm.
up.
Yep.
uh, so how do we want to tackle this? We got so many really good, juicy questions that were pre-submitted. I'm scrolling through the Q&A that's live, and there's a lot of good ones there too. How do you want to prioritize these?
Let's hit some of the pre-submitted ones first. I feel like
Yeah,
they did their homework and
they
they
did. Yes. So
very proactive.
shout out Garrett. So Garrett categorized the pre-submitted questions for us. So there's problem tenants, death of a tenant, lien laws, eviction, and taxes and fees. So I'm gonna
Yeah.
start with problem tenants.
Yeah, let's do
Uh,
it.
so Joni asked if a customer stays past closing time after being told the rules multiple times, can I charge them with trespassing? I think you probably can't charge them with anything, but you can or legally, you're not the person to charge them. But what can they do? What what options they have there? So Joni is a really good question. I got a client who's loitering or a client who's sticking around well after gate access hours. What are my options?
Yeah, that's a great place to start. So yes, you should absolutely report that to your local police. And as Tommy said, it's not you charging them with anything. It would have to be the police making that charging decision. But you should absolutely report that. And that emphasizes the reason why it's important to have a positive relationship with your local police department, because
Yep.
frankly, not every police department is particularly responsive to those type of concerns, but if you have a good relationship with your local department, they're much more likely to be responsive. So that's part one of the answer. Part two of the answer is this is the area that is ripe for uh, you taking affirmative steps on your own and not just simply relying on the police. This person, depending on exactly what they're doing, will affect your timing, but that person should get a notice of that you're not renewing their rental agreement for the next month, and they should be coded out of
Mm,
your facility and given an opportunity, a reasonable opportunity to remove their property. But you should not have to tolerate that person continuing to violate your rules. It can get dangerous if they're there after hours. Jeff Greenberger, one of my legal colleagues in the industry, I think he and many others have pointed out that nothing good happens at 2 or 3 a.m. And that's absolutely true. So you don't want that type of situation occurring at your facility. So yeah, it's
Right.
as much as you want to rely on the police for as far as that can go, you need to take your own steps as well.
I love that. I think this falls under the category, don't let the problem fester.
Yes.
Yep.
And I'm seeing good
Exactly.
advice in the comments here, like document everything, document the behavior, in case you need it, or in case you need to use it in the future. Safety first, Stephanie says. So yeah, these are all good stuff.
Mhm.
Very nice. Melissa, I think this question from Bethany is a good one.
Yes.
And it's one that comes up all the time. This is one of
I
the
love it.
it's one of the
I
99% that Joe was referring to.
It really is because we've all had this situation. So, Bethany says, I have two tenants who have one unit they've been sharing since 2021, boyfriend and girlfriend. That's how it always starts. The lease was signed by the boyfriend, but the girlfriend's been paying for the unit with her credit card 99% of the time. but now they've broken up. And the boyfriend says, "Oh, you can't access the unit without me. Sorry." But he has moved 2 hours away and doesn't have a vehicle. Probably one of the reasons why they broke up. Who knows? But what can Bethany do to handle this legally from her position?
Girl, that's messy.
Yeah, wow, it is. But there's a lot to get into there. So the first legal principle to consider, and Bethany's getting at it, the contract is between one person and the facility. In this case, it's the boyfriend. So even if the girlfriend's property is in the unit, yeah, she's legally speaking, yeah, has no standing. Even if she's an alternative contact. And I think some people will kind of get into that area, but oh, but it's an alternative. Doesn't matter. And then there are some folks, Bethany's question doesn't get at this. Sometimes you'll have the authorized access. Get rid of that in your rental agreement. It's just a disaster waiting to happen. And this case points to exactly why that is. So this, yeah, if the boyfriend is not ex-boyfriend is not willing to play ball, the girlfriend's going to have to get a court order to get access to
Mm.
that property, unfortunately, or maybe she can get the police involved and they'll try to intervene on her behalf. But yeah, there's really nothing that you can do in that case. But I would say that if the uh so that's the strict legal answer. But yeah, kind of on the practical side is, as I like to say, you can't unknow what you already know. So you know that this ex-girlfriend is out there and she's claiming that some property in that unit is hers, or maybe all of it's hers or whatever. um so if this tenant goes into lien status, which it sounds like he might, you would want to take some additional steps there to notify her, because maybe she will want to, maybe that'll prompt her to try to take some legal action to get access to that unit, or make payment on that unit so it doesn't get sold.
Okay. I
Love it.
like it.
Yep, love it. So we'll move to the other category that comes up, and that's the
Yep.
death category. So Greg asked, if a tenant passes away, what documentation, if any, does the next of kin need in order to access the storage unit?
Yes, this I could take the remaining 15 minutes and then probably another hour after this to answer this question. So I'm gonna be brief on this one, and the answer is gonna vary from state to state. So I'm gonna talk kind of in generalities here. Let me start with what doesn't matter, or what doesn't matter on its own. So if there is a power of attorney, that doesn't matter. Power of attorney dies with the person who's passed away. Power of attorney doesn't matter anymore. Death certificate, important, but on its own, not sufficient on its own. Same with a will. I'd probably put that more in the power of attorney category. Wills can change at any time up until the person dies. So you can't necessarily rely on a will, even if it's signed the day before the person died and you know it's real and all that. Maybe there's one after that, or maybe there's
Mhm.
maybe there's an addendum that you don't have or something like that. And then finally, the alternative contact in the rental agreement, that also doesn't, that's completely irrelevant for these purposes. That might be a person you want to communicate with if you're not hearing from anybody, but that person does not have any legal standing. So to go back to the question, oh, and the other thing I want to answer is, or mention, is that if there is somebody who can access the unit without your involvement, they have the gate code, they have the key, you can let them access the unit. You don't have to deny access in that situation. But back to the original question, the death certificate, you're gonna want that obviously to verify that the person's passed away. But then this is where things can vary from state to state and depending on the situation. If the person does not have a will and the individual, the next of kin, comes forward with a small estate affidavit signed, they can, yeah, they can they can likely access the unit with the death certificate and that small estate affidavit in many states. If there is a will and the case is being, and that small estate affidavit is going to protect you because it's the person who's signing it saying under penalty of perjury, I'm telling you the truth. So you can give access if you receive that documentation. If there's a case going through court, you're going to want to know that the person you're giving access to is authorized by the court, not by the will, but by the court, as the executor of the estate of that individual. And then if you have that documentation, you can give access to the unit at that point. I think I limited that to about 2 minutes, but I could keep going, but I'm going to stop there.
Greg,
Good
hopefully
job.
that you did it. I mean, yeah, so you get the documentation. You want to ask the second one? Is it, or is it, it's
No, I was gonna
yeah,
actually mark through that one because it's about the same.
it's
I was
about the
gonna,
same. Yep.
yeah, I was gonna jump to the lien law question. Because I feel like I hear this one a lot too. Lillian asks, a tenant comes in and makes a $150 payment on a $300 balance, and we accept the payment. If they then stop paying again, do we have to start the lien process all over, or can we continue to proceed with the auction?
Mm.
Gosh, I detest partial payments.
Yes.
So the first piece of advice is don't accept partial payments, unless the only exception to that, in my opinion, you make your own business decisions, but in my opinion, the only exception to that is if this is a pay to vacate. They're giving you a partial payment and they're getting out. Fine, take what you can get and move on. Again, back to the issue of don't let problems fester. If the person can't pay you now, the person's probably not going to be able to pay you later. So,
Right.
but to answer the question of, that's been presented, in most cases, I would say you would have to start the process again. The exception I'll make to that is that if you have been absolutely crystal clear with the customer in writing and in any oral communications, the oral ones are where it can get a little funny. If a manager's like, oh, no, it's okay, we'll take this. You need to make it crystal clear in any communication with the tenant that a partial payment does not stop the process, and you are not going to stop the auction until you are fully paid. If you've done that and you feel confident, you can continue with the process without having to go back to the start. If you have even an inkling of a doubt about that, you want to start the process over again to make sure. And when you start the process over again, don't make the same mistake and take a partial payment again.
Right. I see all the comments are saying this is why we don't do partial payments. Just don't do it. It's just
Your
not a good idea.
your words getting out there, Joe.
Uh-huh.
So
I see a question there in the chat that I just want to quickly respond
Mhm.
to. Does that mean if it's in the lease, we're good? It's got to be more than in the lease. You don't want it to just be fine print in the lease. It's certainly important to have it in the lease, but you want it in the lien letter. And there is, I think, Indiana, there's one state or maybe a handful of states that specifically say in the lien letter that the process doesn't stop if there's a partial payment. But even in every state, you want language saying we are not stopping until we receive payment in full.
wow, there we go.
Good
So,
stuff.
so this next one has to do with eviction, which is an interesting situation here, right? So Holly asked, "Hey, I have a tenant who was given an eviction letter in August of 2025. She was on the do not rent list, but a different employee rented the unit to this person. Do I have to give a reason for the eviction?"
Good question, Holly. Generally, no. And the way I would, in fact, in most cases, in virtually every case, I wouldn't, because I think it just kind of gets into the he said, she said of, well, I didn't do that. I wasn't trying to live in the unit, or I didn't harass the manager, whatever. You have a month-to-month contract with, you should at least, I hope you do. The standard in the industry is that you have a month-to-month contract, and you can, just like the tenant, you can renew or not renew that contract for any reason. There are limits in terms of discrimination, that you can't, non-renew everybody of a certain race, or every woman, or every man, or every person of this or that religion. But that's obviously not what you're talking about here.
Right.
For this particular person, you can renew or not renew for any reason. And I would say, and I'm kind of sensitive. Some other attorneys in the industry aren't. I don't mean that as a criticism, but I'm sensitive to non-renew versus terminate. What you want to do is not renew that contract, and say to her, it's October 23rd today. It'll be a little tight to let her know by the end of the month, but depending on what your contract says, you can say, we're not renewing for the term starting November 1st. You need to have your property out.
Yeah.
And then depending on what state you're in, that may have been a state where we were already able to pass legislation that deals with how you would dispose of the property if the tenant doesn't remove it. But feel free to send me an email about that.
Yeah.
So she's in Oregon, according to her, the chat she just added, she's in Oregon.
Okay. Yeah, that's not a state where we've addressed that yet. But I'll make the offer now. But if there are any questions we don't get to, I'll put my email address here in the chat, and I'm happy to get with people on the side and answer any questions that we're not able to get to, or that require follow-up.
Yeah, and there's a lot of conversation happening around evictions where, I've evicted someone, told them they can't come back, and 2 months go by and they're still here.
Yeah.
And that is exactly why SSA is pursuing this eviction language in so many of the states, because we see that this is a big problem that a lot of you are dealing with. And so, maybe you can go into a little bit more detail on that when you answer some of those questions after the show, because I feel like a lot of these things are going on around this. The next question that I would like to look at is, can we legally use text messages for following through on abandoned units when the customers will only communicate with text and you can't get them to actually come in and sign anything? Is a text enough?
So what you're asking, Melissa, is using that as acknowledgement that they've abandoned the unit.
Right.
If you have yes, if you have a way to store that information within your management system and show that that is coming from the mobile number for that tenant, I am comfortable with that. I would make sure in that case that you follow up in writing, whether that's email or snail mail, with that customer, and say, here's the information we've received. We're deeming this abandoned, and we're going to dispose of the property on or after X date. And if this information's wrong, please let us know immediately. But I am comfortable within the parameters I've set. I am comfortable with using text messages as acknowledgement of abandonment. Yeah. That,
Okay.
just frankly, yeah, we all know that there's just some people, especially the ones who are younger, or just kind of want to avoid confrontation or whatever, that that's the only way they want to communicate.
Yeah. And I think we're all used to having that confirmation email come through of like, hey, we saw you change your password. If this wasn't you,
Yes.
please let us know. But
Exactly.
you don't, if it was you, then good, you don't have to respond, kind of thing. So you're talking about that kind of follow up. I like that.
Exactly. Yeah. And I saw Anne's comment, which I really like here. You could text links to an e-sign portal. That's even better. But if for some reason they don't even want to do that, again, I am comfortable with relying on text message.
Yeah.
Okay. Cool.
That's awesome.
I like it.
So this one has to do with taxes, and this last one that we'll ask pre-submitted, and we'll jump into the live Q&A because there's some good ones there too. But Greg asked, when charging tax for vehicle storage, is it only applicable to an RV or camper that is driven rather than towed? Is there a difference? And I imagine that's probably a very much a state specific thing. But Joe, do many states distinguish between an RV that's towed versus an RV that's driven?
Yes, yes. There are some states that distinguish between whether it's parking, which would deal with a vehicle that's operable, versus storage,
Wow.
and dealing with the vehicle that's been towed there and I assume is inoperable, which there's a whole other reason not to let people store inoperable vehicles. We won't get into that now, but I'll just throw it out there. But yeah, that's going to be very state specific in terms of what is or isn't taxable. Florida is an example where, there are distinctions that frankly just make no sense. But that's tax law for you. So I'm happy to answer that in a follow-up if you want to give me your state, and depending on where you are, there can be county variations to that as well. So if you want to let me know where you are, I'd be happy to provide additional follow-up to that.
Yeah, that'd be good, Greg, if you want to pop that in there. Melissa, how does Tennessee handle it? Do we have to do sales tax for parking here, or?
Yeah, we recommend that too. We had a question in our tax code, like the code itself doesn't come right out and say it, but the instructions on how to complete it does. And so we were like, okay, let's just go ahead and pay this.
Yeah.
And then yeah, like Joe said, there is a difference between whether or not it's a drivable vehicle or not. So yeah, there's little nuances in every state. So join your state association.
There you
How
go.
many times can we fit that into one episode? Okay, I've seen this question come up in the chat and now it's on the Q&A. What legal provisions apply if a tenant causes damage to the facility gate or any other property?
Yeah, that's another great question, and not to belabor the point, it shows, I think, further need for that eviction process in law that we've been talking about. But you should have a provision in your agreement that addresses what happens if the tenant or somebody that the tenant has invited onto the property does damage to your facility. You need to have a language in there if you want to pursue that, pursue recovery for that, for whatever that issue is. I'll add though that the question often comes up in these type of cases of, well, what if the only amount they owe me, they're current on their rent, but they're refusing to pay me for damage to the gate? Can I put them into the lien process? I would say most rental agreements I've seen do allow for that, but I am always very reluctant about that and how a court might approach that situation if they were to face that. Okay, the tenant's current on rent, and their only non-payment is on this issue that's not directly related to the rent. So I would be more comfortable pursuing that type of issue or pursuing that type of damage payment in a small claims court than I would be using the lien process for that non-rent related failure to pay.
There you go.
Okay. I'm
So
trying to
now we
think
get to,
through
there's
these.
so
I
many
know,
good
I know.
chunky ones. Shauna, you've been so patient. I'm gonna ask yours. You were the first one. You actually submitted it in Lobby Talk. So
Yeah.
I have a tenant who lives out of state. He was behind, but he did make his payment, came in during the weekend, and only vacated a portion of the unit, leaving all the junk behind, including a mattress. I tried to buy a hazmat suit for my maintenance supervisor. Yikes. He will not respond to anything that he vacated the unit. His payment was also returned. Do I still have to go through the entire lien process since he can not confirm he vacated? It is absolutely junk, and no sane person would bid on this unit.
Well, let's all agree that not every auction bidder is a sane person. So we'll start with that.
One man's junk.
Exactly. Absolutely. This is all talking of questions we get frequently. This is another frequent flyer.
Mhm.
I'm always a little uncertain on these type of questions. So there are a few states out there, maybe 6 or 8, something like that, mostly in the Northeast, that have language allowing for disposal of low value units. If you're in one of those states, Shauna, that might be something to take advantage of. But I am kind of answering the question more broadly, though. I am always reluctant to use a disposal process, even if you have one in law, if there's some uncertainty around whether the property's been abandoned. It's always safer to conduct the lien process. If there's like literally one item and it's like a busted up end table or like a an old kiddie pool or something like that, okay, sure, you can make the easy judgment call on those. But if it's something other than the very easiest type of judgment call, the best answer is always to proceed with the auction. And the
Mhm.
reason I say that is that nearly every state has legal protection written in the statute, but that legal protection is contingent upon you following the statute as written and not just freestyling it, uh, yeah, as you could do if you declare property abandoned. And that the way those statutes are worded is that whatever is generated from the sale is the maximum amount that can be recovered. So if this is something that truly no sane person is going to want, I'm guessing that you're not going to get anything for it. And at that point, you could certainly dispose of it if it has no commercial value. But you want to first establish that lack of commercial value through an auction. That's always the
Mhm.
safest way to go.
There you go.
All right. I like it. You want to try
Yeah.
to ask one more before we wrap up?
Let's do one more and then we'll wrap up. Which one do we love here? There's lots of good ones. Oh, honestly, Max had a good one here. And I know Georgia's been trying to battle this for ages, so I think this is a good question. The state of Georgia has passed the newspaper requirement that paying the tenant eviction process and the towing provision. In your mind, what should Georgia or GASA aim to go after next? So yeah, getting the newspaper requirement for the lien process is a pretty big deal. But what's next? What's the next big thing that Georgians or any state that hasn't already tackled it, what should they go after next?
Well, let me first start off by thanking Max and GASA for their great work on eliminating that newspaper advertising requirement. I'm going to riff just a little bit here. The newspaper association in Georgia is one of the most powerful I've dealt with. They have a very good lobbyist who, thanks to the good work of GASA, really didn't even publicly fight the bill. He was trying to work the back channels, but because GASA had done so much great work in the off session meeting with legislators and getting them to understand our concerns and how this requirement was so antiquated, it, the press association was reluctant to come out publicly against our bill. And again, they tried that backroom smoke filled room type of stuff, and it didn't work for them. So thank you, Max, and thank you to the GASA board for their great work. Uh,
Woo!
we've yeah, we've had a good run in Georgia. So I'm really happy with where the lien law is in Georgia now. Georgia, this past session, as we've just mentioned, passed the newspaper reform. The year before that, passed some of the new provisions that we've been talking about around eviction and unsigned rental agreements. And then the years before that had passed the elimination of certified mail and late fees and all that type of stuff. So I think the law's in a really good place. But Max, if there are remaining concerns for operators in Georgia that you'd like to see addressed, whether that's within the lien law or it's something around property taxes, which we haven't touched on yet today, we're always happy to have those conversations with you and any other state association to figure out how we can partner and make the regulatory landscape better for the industry. But the final piece of your question there, Tommy, in terms of what other states, again, our big push is on this eviction language and the unsigned rental agreement, and then the handful of states out there that still have that newspaper requirement. That's really where our offensive push is focused now. But there are issues that might be specific to one state or another that we'd love to tackle those as well. So if you're having any issues, I'll make the final plug for state and national membership. Let your state association know. Let our national association know. We'd love to work with you to get those reforms done and improve the environment in your state.
There we go. Love that.
Perfect end.
Yep.
I love it.
Love it. And Max, thank you, my friend.
Yeah.
So question of the week, Joe, and I, you've given lots of fabulous advice throughout this conversation already, but what are the top 3 pieces of legal advice for every storage business? So what are 3 legal things that every storage business should pay attention to? Go.
First, second, and third, make sure your rental agreement is drafted by a self-storage attorney. I can end it there. I'll expand on that answer, but yeah, I could end it there.
Your divorce
I
attorney
see
guy doesn't need to write it for you.
Yeah, exactly. So there's the concept in to make maybe an attenuated connection here, but the German theologian Dietrich Bonhoeffer, great person to read about if you haven't. He talks about cheap grace. And you can't kind of pretend that you have grace. You actually have to believe it in your heart. I kind of make the analogy in self-storage. Don't be cheap around a rental agreement. You have a multi-million-dollar asset. Take it seriously.
Yeah.
And a few $1,000s to get a properly drafted rental agreement from a self-storage attorney is going to be well worth your time and money for all of the lawsuits that you avoid because you have a rental agreement that has a value limitation in it, that has waivers of liability, that has the late fee provisions, has all of the minimum state requirements, et cetera, et cetera, et cetera. So that is literally answer 1, 2, and 3.
Love it.
Yeah.
I will give a second one. Operators need to have a written process and procedure that they follow for every single lien enforcement.
Wow.
I have seen way too many, and Melissa has seen way more than I have, but I've seen way too many examples from members or from news articles out there about something that went awry in the process of, well, we meant to sell unit 1, 2, 3, but we actually sold unit 3, 2, 1, and now now we're on the local news as the bad guy, or we've been sued, or whatever the case may be. Have a process, have a way to double check, triple check that process. I'll go back to Melissa's point earlier. Don't be afraid to pull the trigger. But make sure you are following that process the same way every single time.
Yep.
And we have a lot of resources at the National Association, at the state associations that can help you with that through our lien law manuals, through our legal resource center. So please take advantage of those resources out there. But yeah, those are the best piece of advice I have to wrap us up today. But yeah,
and join your state association.
Yes, and join
There's your number 3.
Yes.
Yes. But you're right though, because I love your second point about having your processes in writing, because you can't double and triple check yourself if it's all just in your head.
Mhm.
You have to see what steps am I supposed to follow, first of all, and most of your state associations have timelines that you can actually just print off that go right along your timeline process that you're supposed to follow, and then you can make your notes for that particular unit. And then, you know, the weeks leading up to the sale, you have documentation that you can then go back and you can double check and re-verify over and over again right up until the date of the sale, so that you know what, I really did do everything I was supposed to do for this
Mhm.
process. And that will help you feel more confident in, I can go ahead and follow this completely through. Or okay, I see where this is kind of gray. Maybe I didn't do this completely. Okay, I do have legitimate reason to start this process over again. But you can't double and triple check something if it's all just up here. So write it down every time for
Yep.
I
every
love it.
unit. Yeah.
I
Here,
love
here.
that.
And then all of that documentation goes into your file, and you've got a bulletproof case if this tenant wants to try to cause some trouble for you later.
There we go.
Exactly.
I love it, Joe. Well, Joe, I've already sent off a couple emails, Greg, Stephanie, a couple others to your inbox. But what's the best way for folks to get a hold of you or the SSA at large if they have more questions about how to handle legal issues in their storage business?
Yeah, so thank you for this opportunity, Tommy and Melissa. This is always so much fun, and I look forward to coming back with y'all in the future. But the best way to find us is at selfstorage.org. And then I'll type my email address here into the chat box again. It's J Doherty, first initial, last name at selfstorage.org.
Very nice. Well, Joe, we always love having you, man. And Scott was here too, and I know you mentioned Jeff as well. So I think we're well supported on the legal front here in our industry, and so thank you for all your time and expertise, sir.
Yeah, of course. And I do want to I know I've acknowledged him earlier, but I also want to acknowledge my colleague Daniel Bryant, who we wouldn't be able to do the stuff that we do
Absolutely.
without Daniel. He's boots on the ground in state capitals, but a lot of the kind of the background writing through the legal review that we do, he does that with Carlos Caslow, all the lien law manuals, all the information on the Legal Resource Center. That's Daniel's handiwork. So kudos and thank you to Daniel for all the great work he does as well.
Incredible. And Carlos as well. All
Yeah.
good names.
Yeah.
So absolutely love it. And the entire SSA crew for hosting it and putting it together. So Joe, we'll see you. I think you said Raleigh, you'll be in North Carolina, and I
I will
think
be.
you said you'll be in Detroit.
No, Daniel will be in Detroit.
Daniel be in Detroit. All right. So say hi to Daniel for my Detroit folks, and the Raleigh folks. You'll see Joe in the flesh here in a few weeks.
Mhm.
But yeah, and then you'll see Melissa and I back at it the week of or the week before Thanksgiving here. Self storage finances 101. I think this one is a topic that's been long overdue. I don't remember the last time we talked money on Gabfocus.
It's been a bit.
It's
Yeah.
been a bit, but we
Yeah.
got two really sharp people. We got Brooks Lumpkin, who owns a bunch of facilities down in Georgia. He's a big part of the Georgia board. We shout out GASA moments ago, and then Amber from Live Oak Bank, who does a lot of lending in our industry in their self storage
Awesome.
wing. So,
Yeah.
two
Great.
fantastic speakers to talk about finances and self storage. We're going to talk about lending. We're going to talk about refinancing. We're going to talk about raising money, and all the things. So, and of course, we're talking about revenue because that's a big part of your finances. But yeah, so that's going to happen November 20th here in a month. You can catch this episode and all prior episodes on the official Gabfocus Self Storage podcast. Josh will get that live sometime in the next 24 hours. You can also catch this entire episode live on YouTube on the official StoragePug YouTube channel as well. All right, so y'all have a fun rest of your week. Enjoy your fall weather. Melissa and I will see y'all next time. Thanks, Joe.
Hey, y'all.
Thanks,
Thanks.
Melissa. See y'all.